Okay, great. So let's say if I give you an example, suppose I have a bakery shop. If I have a bakery shop, what does it constitute? Is it a property or an intellectual property? I have a bakery shop. It's a property, okay. And let's say there's a recipe I have made, a secret recipe I have made, which is used by me to develop a cake. And what part of the intellectual property would you classify this as? What? It's a trade secret. It's a trade secret, basically. Okay. And let's say there is a list of customers that I have, which I have saved in my database, which I don't want to share with anyone else. What would it constitute? What kind of IP would it constitute? A list of customers. Anyone? It's again a trade secret. Is that the car? Yeah. Can I start? Alright. So let's start. I think my name is Amit Goyal, and I am founder and director at Effectual Services. It's a IP consulting and advisory firm based out of Noida, and we have a team of 250 plus techno-legal experts. We have offices spread across globally, including US, Germany, Singapore, England, London, and New Delhi. So today, what I'm going to touch upon is primarily make you understand the basics of intellectual property. I'm sure there will be further sessions that would be much more deeper into the details, but today what I'm going to talk about is primarily all the different types of IP and have a discussion more centric towards patents. What is a patent? What are the filing processes of a patent? Where you can file it? How much time does it take for a patent to be granted? What are the advantages of it? And certain examples that I will showcase to you. Okay? All right. So a brief about the contents. So this will be the key agenda of our discussion for today. Primarily basics of IP, patent, trademark, copyright, GI, trade secrets and designs, and then what can be patented, what is the life cycle of a patent, what is the process of filing a patent application, different types of patents, and what are the databases that you can use to perform any kind of search for a patent literature. Alright, so let's start with what is intellectual property. Primarily, as you said earlier, if I have to classify a property is a tangible asset, right, which you can touch and feel. And the way you classified a bakery as a property, or a laptop or a computer that you may have, all of that is classified under property, and asset that you can touch and feel and own it, really own it. Okay? And then comes intellectual property. A property which you can't feel. It's an intangible asset. All the creations resulting from human endeavors, so from human mind, whatever could be created could be classified under intellectual property. One, let's say science, anything that you do under science and technological fields, under, let's say, artistic work that you do, or literary work that you may do. So everything and all would classify under intellectual property. Some of the examples could be, one, as you said, all the inventions that you create. Inventions would always be equated with patents. Second, all kind of literary, artistic work or any scientific work that you may do. So again, it will be classified under copyrights. Third, it could be industrial designs. So a patent is, there are three types of patents. One are called as a utility patent. Again, those are technology patents. The second are the design patents, which we call it as, in India we call it as industrial designs. Okay, and third are called as plant variety patents. Other type of IPs, geographical indicators. We'll touch upon all of these in some bit. Then trademarks, trade secrets or service marks. So all of these constitute intellectual property. So when a government assigns rights associated with these intellectual properties, we call it as intellectual property rights. Then you get certain rights which you can apply in the court of law. Okay, so those are the intellectual property rights. So we'll talk about each right in the further slides. So the purpose of having or creating intellectual property was to create or to evolve the evolution of technology. You don't want to restrict yourself to older technology. You would always like to evolve technology. So as you can see in this slide, there was somebody who would have developed a wheel, and from prior knowledge plus some human innovation came another invention. So there is a need of the art that we need to create certain new evolutions of technology, otherwise we won't be able to survive in our humankind. So there's always a need to create new innovations over a period of time, and IP acts as one of the primary source of information that could drive innovation. Okay, so if you would not have known probably, let's say, a wheel, somebody may not have conceived a bicycle, or a bicycle to tricycle, or tricycle to a car, or to an aeroplane, or aircraft, or something else. So there is a need for knowing something and then applying some knowledge into it to create something new. So there are two types of, if I have to classify intellectual property rights, there will be two types of intellectual property rights. One which is associated with the owner, who owns those rights. Second are the rights which are associated with the public, who can access the rights. So if you see on this slide, you see the rights which are associated with an owner are primarily the legal or the economic rights associated with whatever that person has created. So those will be rights associated with the owner, while the public, in lieu of those rights being given to the owner, would get a free access to that information. Because I as an owner will get rights only if I publicly disclose that information, most of the time. Okay, apart from trade secrets, all the rights that you get in intellectual property, primarily you need to disclose it to the public so that further developments can take place in that area of field. Okay, so public gets an open access to the subject matter. Public can start using that technology. Obviously, you need to take all the legal requirements of licensing and everything, but you can fairly use that technology once that comes into the public domain. Third, one of the key things is that you can question the other party. The owner of the IP could always be questioned that on what grounds or why that invention or why that IP rights have been given to that person. So these are the three primary rights which are given to the public for public with respect to the intellectual property rights. And please feel free to question in between in case you have any doubts. We can have that discussion at the end as well, or in between as well. Alright, what are the key advantages which are associated with intellectual property? First and foremost, primarily to prevent theft, counterfeiting, piracy of the intellectual property that you own. You could try to enforce your legal rights. Second, again, for a country like India, it gives an avenue for economic growth of the country, and again increases the competitiveness as well. Third and foremost is the innovation culture that is created in a particular country. So innovation, economic growth, competitiveness, protection, legal protection against your rights in terms of nobody could reuse your technology, counterfeit it, or even mark it as a piracy. So as I said earlier, these are some of the kinds of IP that we would touch upon, and primarily take the discussion further into patents, which we'll talk about much more in a detail. From a university perspective, I would say patents, copyrights, designs, and probably trademark. These are the four areas of IP where you may be using in your particular technological areas. So we'll touch upon each of these in the subsequent slides. What is a patent? A patent gives an exclusive right. Remember, it gives an exclusive right pertaining to an invention, which could be a product or a process. For what? For doing something new or for solving a problem which is currently there. So these are exclusive rights associated with a product or a process. Third, something new being done or some problem has been solved. These are the three primarily things that when we talk about anything about a patent. There is a term which is associated with patents, how much time period the validity of a patent is. It is primarily across the globe, it is 20 years. Lot of people ask me a question that is patent global? So patent is not global. Patent is jurisdictional restricted. That means in each country, wherever you want to file your invention, you would have your legal boundaries limited to only that country. So आपने अगर इंडिया में फाइल किया, you have legal rights only limited to India itself. You can't enforce your legal rights in other parts of the world. So you need to ensure that you need to file your patent across different countries, wherever you think that you want to apply your business on. Okay. Second are copyrights. I think most of you would be using copyrights in one way or the other. You must be writing a lot of research papers, right? So all your research papers, even this presentation, would act as a copyright. So all of the literary work, all of the artistic work that you create, which is original of your own, would act as a copyright, which may include, let's say you write a book, you write a research paper, some music being created, some computer program which is created, all of that would classify under a copyright. Okay. Again, please remember, don't equate a patent equivalent to a copyright. Copyrights are primarily acting as expression of thought. It is not an idea. So very different. Patent, it's primarily innovation. A pure play technical innovation takes place. While in a copyright, it is just a way of writing something. A way of writing could be a computer program, a music compilation, anything on that front would all act as a copyright. So please remember, a lot of times people come to us and say, I want to file a copyright for my invention. So that's completely wrong. So please bear it in mind what to differentiate when it comes to a copyright and a patent. Now, what is a way to file a copyright? The primary requirement to file a copyright by the Trademark and Patent Office in India is it has to be original. If your literary work or artistic work is original, it could be copyrighted. Now there are two ways to file a copyright. One is you don't need to go anywhere, just write a C mark on your presentation or your document. It automatically starts acting as a copyright for you. That's one way. The other is a formal way of protecting your copyrights, wherein you may request the Trademark Office in India for protecting your copyright work. Okay. The term of a copyright is around 70 years from the day the author dies. So that means you get an ample amount of time for your copyrights. Vis-a-vis a patent. Patent was just for 20 years. So, but remember, copyrights in your field, copyrights would be mainly limited to probably research publications or computer software codes that you may be preparing. Any doubts till now? Any questions that you may have? All right. Next kind of IP right is trademark. Again, a startup or an entrepreneur may like to protect their brand, and primarily trademark would define as a sign that individualizes a good or a service. So there's a mark which individualizes a good or a service and distinguishes it from others. So there are two things. One is it has to individualize a particular good or a service, and it is able to distinguish it from the others. Some of the examples could be all these marks you can easily see, and you can easily resemble the name corresponding to each of these marks very easily, because you know the brand sign. From there you can easily understand the company or a product or a good or a service which is associated with these trade names, trademarks. So the key characteristic when it comes to creating a trademark are two primarily things. One, it has to be distinctive. So if you file a trademark in a trademark office in India, they will determine it on two grounds. One, it has to be distinctive. Second, it should not be deceptive. Distinctive and not deceptive. So when I say distinctive, it is able to distinguish your goods with the other goods and services being sold in your industry. Again, it should not be a generic name. So these are primarily some criteria on basis of which and second is it should not be deceptive as well. It should not mislead that it looks very similar to some other brand. Have you seen a trademark for, let's say, Paytm, right? And there is another company with the name PayPal. And if you look at both those trademarks, the pay word PAY very closely resemble it with Paytm. And there was a case which was filed by PayPal with Paytm that why they are resembling into the same trademark. It's a deceptive kind of thing. So keep in mind whenever you create any kind of trademark for yourself, keep these primarily things in mind: distinctiveness and non-deceptiveness. So if any of these are fulfilled, they will be granted. In this example, the second one, the green vegetable company, it is very generic in nature. So the patent office, when we filed the second mark, the green one, was rejected, while the first mark which was filed at trademark office was granted because it had certain unique associated drawing vis-a-vis the first one. Okay, how can we file a trademark? What is the process to file a trademark? Again, very simple. You need to file the trademark at the trademark office in India, and some of the requirements, some of the reasons why we file a trademark is: one, primarily my brand should not be damaged. I need to protect my brand. My brand name is very important. Like I'm assuming GLA University by themselves may have protected a trademark for GLA University, or their logo would have been protected under a trademark because they want to protect their brand. Nobody should use the same mark in their goods or universities wherever they are. So one way of registering a trademark is go to trademark office and register it. Second is a long-term association. For example, say Coca-Cola. Coca-Cola is a world-renowned brand, and let's say in one of the countries they may not have filed a formal trademark, but still they would have the legal rights in that country because of the long-term global know-how of that particular brand. So that will be limited to only very big global brands which are known globally. They may not even if they have not filed a trademark, still they would get the rights associated with it. Moving on. Okay, next one. Okay, the next one is geographical indicators. Probably it may not be of relevant to you, but just to give you an understanding of what is a GI. GI is a name. GI is a name or a sign which is used for a specific geographical origin. So जैसे आपने सुना होगा, let's say Darjeeling tea or Swiss watch or let's say Kanchipuram silk. So all of those are associated with the geographical origin from where that particular thing has been created, right? So all of that would be classified under geographical indicators. Another one, as we discussed earlier as well, trade secrets, again which may not be applicable to you to an extent, but trade secrets again are any formulas, any practices, any processes, any designs, any instruments, any compilation of information which is kept secret, which has to be kept in secret, then only it will be classified as trademark. Sorry, trademark, not trademark, trade secret. Okay. Some of the examples could be a formula of Coca-Cola, customer list, or any particular unique manufacturing process that you not disclose it to the public. So all of that would act as a trade secret. So in my company, let's say, the list of customers or list of clients would act as a trade secret for me, because I don't want to share information about my clients with my competitors. One of the interesting other aspects of intellectual property is designs. I think this is one area that I've seen a lot of technical universities filing design patents. So apart from technical innovations, which are classified under utility patents, there's another kind of innovation that you could do under designs. So any aesthetic, any ornamental look of a thing could act as a design. So which could be a 2D shape or it could be a 3D shape. All of that would classify under a design patent. So if you see here at the bottom, there will be a couple of designs which are provided over here. So keep that in mind whenever you are creating. Let's say, if in case you are from computer science background, there could be lot of design inventions that you could create. Specifically, let's say user interface. If a unique user interface design is created, it would classify. You could protect under a design patent. Okay, now let's go much deeper into what a patent is and what are the filing processes and requirements complying to a patent. So if you see on this slide, the first patent was filed in 1449. So which was for glass making process. So it's been almost more than 600 years that have been filing patents globally. And as I defined earlier, it is an exclusive right which is given to the owner of a patentee, which with a limited period of time. So exclusive rights for a limited period of time, in view of which public disclosure of information corresponding to your invention has to be submitted. Okay. So what are the rights which are associated with the patent? I, as an owner, can stop others from making, using, selling, offering for sale, or importing of that technology. So owners have the right to ensure that nobody else starts use that technology. Secondly, the owner also has the rights to sell, license, assign, mortgage, take loan based on the technology that the owner possesses. So both the sides, you have the right to sell your technology or license to your technology, or also stop others from making and using that technology unless until you take a permission or take a license from the other party. Okay, let's take an example here. Let's take a pause and let's take an example here. Suppose there is a company A that manufactures laptops. Okay, so there is a company A that manufactures laptops, and there is a company B that manufactures a device by which the battery power of the laptop increases. So there are two companies. Company A is the one which creates laptop, and company B is the one which creates a device to increase the efficacy of the battery. Okay, so now my question here is, can company A start selling a product which is a laptop which includes that device? Yes or no? Why? Sorry? Yeah. You can? कंपनी ए के पास पैटेंट है लैपटॉप का एंड कंपनी बी के पास पैटेंट है उसकी बैटरी की एफिकेसी को इंप्रूव करने का. एंड माय क्वेश्चन हियर इज कंपनी ए स्टार्ट्स selling a product which includes the product of company B. Can I do that or not? No. Why?
separate patents actually belong to the battery owner. So
Right. So basically, company A is infringing on somebody else's technology. So you need to take a license from company B. Then only you should include that component into your laptop. All right. Okay. Whenever you think about any innovation, you want to file a patent. I think these are three fundamental things that you need to look into. If you think your innovation fulfills these three criteria, then there is a high chance that you would be able to get a patent. So those three criteria are: one, the patent application or invention has to be novel. So if it is novel, then you have the probability to file a patent application. Second, it has to be non-obvious. When I say non-obvious, it means that whatever is known in the art, whatever is known in the technology, you can't just combine it together and use it in your invention. Let's say hypothetically, there is a chair with four legs, and then you come up with a chair with 5 legs. Then though it may be novel, it may classify under novelty, but it will not classify under non-obviousness, because it's very obvious that you could always create more legs of a chair. So you need to think about whether it is novel and also is it non-obvious or not. If these two criteria have to be met, along with the third criteria, that it has to be of use, industrial use. There has to be some application corresponding to that invention. So if these three criteria are met for any invention, then you could certainly go ahead with filing a patent application. Now, how to evaluate whether your invention is novel or not? I'm sure you write a lot of research papers and you do a lot of literature survey, right? You do a background work to understand what is known in the art. So it's like a prior knowledge. What is known in the art? So do a check of known technologies, known literature. Known literature, when I say, it is classified in two parts. One is patent literature, the other is non-patent literature. Patent literature would only be patent documents. Non-patent literature could be classified as, let's say, all the research publications, any white papers that are created, any videos, all of that would classify as non-patent literature. So, as an examiner, when you file an invention at patent office, they would look into those prior art documents, whether those prior art documents, are they also talking about the same novel aspects which you are trying to protect. So keep in mind, do a novelty check before filing a patent application, so that you know what is already known in your technology space. So we've already covered that, so let me skip it. Okay. One of the other important things that you need to look at whenever you file a patent application, any invention that you create has to be classified under either of these 4 classes. So एक तो है novelty होनी चाहिए, inventiveness होनी चाहिए, and industrial application होना चाहिए. But apart from that, that invention has to fall under one of these 4 classes. That means the invention is either a process, second is either a product, third is a end product itself, machine or article of manufacture, and fourth is composition of matter. So if any of your inventions falls under any of these 4 classes, then only you fulfill the initial requirement of a patent application. Okay, so keep that in mind, that a utility patent has to be classified under either of these 4 statutory classes. Okay, just to take you through what is the life cycle of a patent. So obviously, you create an idea. Second is you do a novelty check. You do an assessment whether your invention is novel or not. Once you've done the novelty checks, then you create patent application. Once your application is created, you file the application in a particular jurisdiction. After a certain period of time, in India roughly 18 months of time it takes to get the application published. So once the day you file the application, roughly 18 months it takes in the normal course of action to get an application published. And then obviously there would be some rejections, some examination process that happens where the examiner will review your invention and give some rejections corresponding to your invention. You need to defend your rejections. So once that phase is over, the grant or rejection will take place. And obviously thereafter, you need to pay a maintenance fee year on year. So primarily these are the various stages through which a patent application goes through, right from the ideation till the grant and thereafter the maintenance process. Okay, from the perspective of timelines, roughly, as I said, the term of a patent is for 20 years from the day the application gets filed. So the term is 20 years, and roughly publication takes place in 18 months of time. The rights which are associated with patent only start from after the grant of the patent. You can't, if you file a patent today, you don't have the legal rights corresponding to that invention. The rights that you get are after the grant of the patent. So you could always say a patent pending when you file a patent application, but all the legal rights will start applying from once the grant happens. Although you could always go back from the day it was filed, or you could take all the benefits, but the day you file it, you can't say somebody else that you can't manufacture it. You can always say that only once the patent gets granted. Okay, now, yeah.
Can you please go back to the previous slide once?
Yes.
So there it is given that from the filing date to the expiry date, it is the arrow is given.
Yeah.
For 20 years period. So will it be from granting date to the expiry
No,
date?
the date, it will be for 20 years from the filing date. So legal rights will ultimately be applied from the filing date, but you can start applying your legal rights only after grant. See, आपको grant ही नहीं मिला तब तक आपके legal rights थी नहीं. आपको grant मिल गया, then before those जब आपने file किया था till the grant period, you have the legal rights to take let's say any legal injunctions that you want to apply. You can do that. बट आपकी जो लीगल राइट्स अप्लाई होंगी वो स्टार्टिंग ग्रांट डेट के बाद में, बिकॉज आपको ग्रांट मिलेगा तभी आप कुछ इंश्योर कर सकते हो कि कोई और यूज मत करे.
सर मैं क्वेश्चन मेरा ये कि 20 इयर्स जो कैलकुलेट होगा
वो फाइलिंग डेट से होगा.
फाइलिंग डेट से
होगा. And to be very honest with you, in the field of computer science and electronics, I don't see nowadays people using the patent for 20 years. Probably because this is the industry which changes or transforms every 6 to 8 months or 12 months. You'll see a completely new technology coming up. So nowadays, as a company, I would not, though I filed a patent, it is granted to me for 20 years. I may not pay the maintenance fee for all 20 years. I may revoke my patent after 5-6 years if I don't see any business or commercial value corresponding to my invention, because then the invention is obsolete. Though for drug industry, pharmaceutical companies, it is very essential because they spend about trillions of dollars for to create one drug for themselves, and then they want to take benefits for next 20 years, so that whatever money they have invested in their R&D, they could use that money in the further areas of time. Okay, so in general, I would say in high tech or technological field, specifically high tech, I don't see people filing and using it for 20 years. Okay, the way the filing process could be done, there are two ways to file a patent application. One is you go to Indian Patent Office. If I'm talking only about India, you go to Indian Patent Office and file your invention. It gets prosecuted and gets either grant or rejection. That's a basic process that happens. The other thing is, if you think that your invention has business value not only in one country but more than one country. Let's say your business value is in India as well as in US as well as in Europe. Then there is a process that if once you file the application in India, within a span of 12 months, you could file another application of the same application in US and Europe as well, or in other parts of the world. So there is a window of 12 months that you get to file a foreign application of the same invention that you filed in your national country. Or even if it is also not essential that you have to file first in India, then only you can file in US. If you think that your business has no value in India, but you have a business value only in US, in that case, take a foreign filing license. In India, it's very important. There is a law corresponding to it that you need to take a permission from Indian Patent and Trademark Office to take a permission that I want to disclose my invention out of India. So once you take a foreign filing permit from the patent office, you could file your invention directly in US or in Europe. You don't need to file it in India. So these are two ways, depending upon. Make a note that a patent has a commercial and business aspect. Any theoretical work that you create which has got no business or commercial value, we don't recommend to file a patent for it. It's a waste of money, a waste of time for your efforts, and because it is not going to be used in the near future as well. So keep that in mind whenever you're creating any invention. Think about whether does it have any commercial aspect to it or not. Will there be any company which will be implementing your technology? If you don't think that, I don't recommend to file a patent for it. Now, the other way of filing a patent is through a medium called as WIPO, a PCT route. So that's a second alternative to file a patent. PCT route has got around 171 member countries in which you file one single application, and then you get a window of 30 to 31 months of time to decide which all national countries you want to file the same application. So typically this is majorly used for a bigger corporate where they think that their invention or their business is going to be in multiple countries. Then I would use a PCT route to file that application across multiple countries. Otherwise, from your standpoint of view, I don't see that happening so often. Primarily, you may be more focused towards filing in India only. So as I said, when it comes to filing a PCT application, this is the basic framework for filing a PCT or an international application. From the day you file a initial application, you get a window of 30 months to decide which all national countries you want to file that same application. But again, please note that this is very expensive compared to a normal national application that you file in India. So I'll also touch upon the cost as well. I'll skip that. I don't think that's needed. Okay, so just to give you an idea of what is the cost, what are the government costs associated with filing a patent application in India. So at the time of initial filing for an individual inventor, for a startup, for a woman innovator, these are the fees which are applicable for all of them. Primarily 4,000 rupees for initial filing. For all of you it will be 1,600 rupees to initially file and 4,000 for examination. So roughly 5,600 rupees are spent on filing a patent application when it comes to India as an individual inventor, okay, or as a startup. Besides that, there is a provision in India to publish your application earlier. You file an application within a span of 2 months, your application gets published. So roughly you need to pay additional amount of 2,500 rupees to get your publication filed earlier. Then there is another provision of expediting your examination as well. For women entrepreneurs, there is a separate process or additional fees to be levied by which you could expedite your examination process as well. And again, some other costs which are there. Okay, the second alternative route that I talked about to file a PCT application, you would see here the cost is significantly very high, 1471 US dollars, so $1,470 just to file the application as a PCT route. So that's why I would not recommend using this route to file any application at your end. Now I'll just touch upon some of the examples. What kind of patents have been granted in the past. So if you see over here, these are some examples which I listed down. Say a mobile agent security in a mobile ad hoc network, and I'm assuming a lot of researchers are there, so they may be working in the field of mobile ad hoc networks. I did my PhD in 2005, 2006 when MANETs were there, but I didn't know at that time that there are a lot of patents also getting filed in this particular field. So there are patents which are getting filed across different technologies, including MANETs. If you see over here, a secured communication in a vehicle ad hoc network, a refrigerator leakage detection for an automobile. So these are some exemplaries which I've shown to showcase to you what kind of patents are being granted in the world. So now I'll show you some examples of very known technologies which you could relate in today's time. This is the first one is Apple's patent, which was a design patent that they filed, which was primarily on the look of the iPhone. This was the first design patent filed by Apple on their first generation iPhone, which was created by them. So you can see that these companies do ensure not only the technical innovation, but they also try to protect their design aspects. So Apple always ensures that they protect their designs as well. You must be knowing a company named Gillette, which manufactures all the razors being used. Gillette has almost got more than 200 plus design patents on their blades. Just their blade designs, they protected multiple design aspects corresponding to it. Second, you must be knowing Graham Bell. So Graham Bell had filed a patent on telecommunication, which was conceived by him on transmitting the voice signals. So again, this was a patent which was granted to Graham Bell. The Wright brothers, who gave the idea of aircraft, right? So they also filed a similar their patent application corresponding to creating a flying machine. So all of these ideas have helped the further generations to create new innovations, because they are the ones who have publicly disclosed their inventions, on the grounds of which new inventions could have been created. The next one is a gene editing technology which was created, again a very groundbreaking technology. A light bulb created by Edison, again a groundbreaking technology which was created in 1878. Again they filed a patent, and Edison had almost 1100 patents to his name. Bluetooth technology, again a very known and useful technology which is being used by everyone these days, again a patented technology. Telecommunication based, all the wireless communication that takes place over our mobile channels, 3G, 4G, 5G, all have hundreds of patents corresponding to it. 3D printers, you would not believe, but 3D printers were initially filed in 1986, and even today we are not using it fully. So from 1986 till now, 3D printers have not been able to potentially use it, and there are so many use cases corresponding to 3D printers. So technology gets evolved. I was surprised to see virtual reality, VR, which was filed in 2000, which was not used for gaming purposes at all. Primarily it was used for analyzing the financial data. So the use case was very different when they created the invention, but later on somebody had thought about ideas of using that same technology in the other technological areas as well. So as you can see what kind of different patents, what kind of different technologies have evolved over a period of time. So these are some of the use cases that I showed which have been protected under patent. Now I'll touch upon some use cases which cannot be patented. It's not that everything and anything under the sun could be patented, right? So there are certain laws, especially in India, I would say, that stop you to get a patent in certain aspects. So we'll touch upon what are the things which cannot be patented. The first, anything done under medical treatment or surgery is not permitted to be patented, because again, those if somebody develops a new surgical technology, then nobody, if a doctor, I as a doctor may come up with a medical surgery methodology, nobody in India would be able to use that surgery technology, which again, the objective is both to use it for the public as well. So that's why these are certain things which have been kept in mind while creating the law. Second, any mathematical formulas, business methods, computer programs, or even the pure algorithms may not classify under a patent. Though you may think that means software patents cannot be protected. No, it's not that way. There are ways to protect the software patents as well, but pure computer program, if you start filing, it cannot be done under a patent, though you could file a computer program under a copyright, because again it falls under a literary work. So thirdly, let's say any literary, dramatic, any musical work that is done, any paintings which are created, all of that would not be classified or cannot be used as a patent. Fourth, anything which is traditionally known, may not be having any written documentation corresponding to it, but from our past old ancient years we've been using that technology, cannot be patented. Like use of turmeric for wound treatment would not be applicable, because turmeric is a very known traditional thing. Fifth, anything which is against the law or which is against the public interest or morality could not be protected under a patent. So let's say anyone who creates a counterfeiting, creating a machine who prepares the counterfeiting notes, obviously it's against the public interest, it's against the law, so you can't get a patent on it. Anyone who creates a gambling machine in India would not be allowed to patent it. So there are things, let's say any device that permits you to do burglary would not be permitted in the law. So there are certain restrictions also when it comes to patents. The mere discovery of any scientific principle will also not act as a patent. Okay, mere new form of a known substance would also not act as a patent. Mere use of a known process would also not act as a patent. So there are certain criteria, some ground fundamental rules which have been defined under Indian patent law that restrict you to ensure that not everything would be granted. Okay, what are the various sections of any patent that you create? Primarily, these are certain sections of each patent application. So whenever you create an application, you would see most of these sections. Similar to a research paper, you define your background, right? You may have certain drawings corresponding to your invention. You may have a description corresponding to your invention. The key difference between your research paper and a patent application is claims. Claims define the legal boundary of your patent, which you don't define in a research paper. Research paper mainly talks about what is your invention about, but there is nothing like what I own. Research paper doesn't give you any legal ownership corresponding to that technology, right? Anybody can implement that technology. So patents, there is a term called claims where you define the legal boundary of your invention, which is typically done by a person who knows the way of writing a patent application. So as I said earlier, there are three types of patent that you could protect. One are utility patents, which we talked about in detail. Second are the plant variety patents. Third are the design patents. We've already covered these, so let's skip that part as well. Okay. So we already touched upon all these aspects. So you need to ensure these are certain fields of a patent application that you need to create. So, okay. Just to give you an idea, since a lot of you may be writing a lot of research papers, how your research paper differentiates from a patent. What are the things? So if you see over here, what are the key differences between a paper, patent or paper, research paper? Exclusive rights are given to a patent. There is no exclusive right with respect to a research paper. Commercialization, because you have a patent, you have economic rights corresponding to it. So you get all the economic rights, while in the research paper there is no economic rights corresponding to it. Third, legal protection. You get legal rights corresponding to your patent. In terms of research paper, there is no legal rights corresponding to your research. Cost. Obviously, the patent may incur much more cost as compared to a research paper. Public disclosure. Because I am getting a patent, I need to disclose my invention. In a research public paper, it's up to you how much information do you want to disclose to the public. Again, public distribution limited to what is disclosed in the document. Research publication, you could widespread your information. Last, patent is an individual right, or an individual, I would say, or a company's right. But when it comes to a research paper, it's a collaboration. It could be a collaboration of multiple people coming together and writing a research paper. So primarily, these are certain fundamental differences when it comes to a research paper vis-a-vis a patent. If there are certain students over here, just to give you an idea of what kind of benefits that you may be able to get if you file or if you own an IP. Obviously, your resume is increased. You get a lot of rights corresponding to. You could have the avenue of licensing revenue rights. You could use it when you create your own startup. You could get a lot of awards corresponding to it. You could create a lot of industrial connections. You get a competitive edge as well. So these are certain aspects of benefits that you may get if you own IP as a student or even as a researcher. Now, just to touch upon certain things about what kind of career that you can look into when it comes to intellectual property. So it's a growing field. Since a lot of you are researchers, you always have an avenue of also entering into, apart from industrial working in industry, you have an avenue of entering into intellectual property domain as well, and you could do a lot of research work when it comes to IP. So there are designations corresponding to patent analyst, senior patent analyst, and so on and so forth, who would be doing lot of technological research in-house to understand and differentiate between what is known and what is not known. Then if there are people from law background, then they could do LLB and act as a attorney or a patent attorney. Then there are other people like patent agents that they can become. Again, patent agent has to be a technological person. You can have a potential of becoming an R&D engineer. And if there are LLBs, there could be a potential of becoming a patent paralegal as well. So there are a lot of career opportunities when it comes to intellectual property rights. Just to give you an idea of what kind of schemes has government launched in the field of intellectual property to incentivize, to give certain benefits to inventors and startups. There is a scheme which is known as SIPP, a scheme for facilitating startup intellectual property protection, which helps you or provides you a medium to file patent applications. Government has reduced filing fees. Government has given provisions to expedite the examination. Government has also created a National Intellectual Property Awareness Mission, NIPM, which is a flagship program meant for IP trainings being created. Then there is another program by Government of India about National IP Awards to recognize the people who are creating new inventions in their own technological fields. In the field of biotechnology, there's an agency known as BIDAC, primarily supporting all the inventions which are creating in biotechnological sector. They support in financial side to file application and prosecute them as well. Atal Innovation Missions are the incubation centers that have been created in lot of technical universities, which are incentivizing the startups to create new innovations. So lot of technical programs, lot of IP programs have been initiated by Government of India to enhance IP filing. And if you see the trend in India in today's time, I think there has been 130% of increase in patent filing when it comes from 2022 to 2023. So a lot of people have started filing IP, and there's a lot of awareness happening in the IP field. Should I stop? I think I'll stop here. I'll quickly, probably let me just take you through certain things. Yeah. Okay. So these are the databases that you could use to understand whether your technology is novel or not. So if you see on the left hand side, there are a lot of patent databases that are listed down just for information which you could use. I would say primarily go to Google Patents. This could be the very good source of your own research and to understand whether your invention is novel or not. I think if you just use Google Patents, it is more than sufficient for you to understand your technological landscape. And on non-patent, I'm sure you would know much more databases which you could use for understanding your technological landscape. Just as an example, say if I have to do a search to understand if I create a new touchpad handheld device. So you could go to Google Patents and do a search on Google Patent. On the left hand side, you will see certain search terms you could apply to perform the search. I think I'll close here. I'm open for the questions that you may have corresponding to whatever we've discussed till now. Thank you so much. Thank you. Yes.
So I'm in a little confusion. So thank you for visiting our department as well. Thank you very much for enlightening us on IP. So actually I want to know, suppose we are developing a model, right? And we have the algorithm for the same. On that case, as you say, algorithm cannot be patented, right? So on that case, how we can patent a particular model?
So algorithm would be able to, you would be able to protect. It would be another method. You would define the process steps,
Yes.
and you would link it to some hardware which is implementing your process steps. So there will be a machine which is implementing your process.
That means the algo can be presented as a process.
Yes.
Rather,
Yes. So it will be a process primarily. So if you form your algorithm as a process,
yes.
having multiple steps in it,
Yes.
automatically it will classify as a patent. Because algorithm, if you write it in the algorithmic form, it may not be patented. But if you write it in the method steps itself, it starts acting as a patent. Because as I said, there are 4 statutory classes:
Yes.
a process, a method, an article of manufacture, or composition method.
Yes.
So you would classify under a process.
Okay, that means the writing should be in a way that it should look like a process rather than
Yes.
algorithm.
Yes, pure.
Okay,
Yes.
okay, sir. Okay, sir. And then the same can be go for process or can be go for design also. And that there will be 2 patent or the same patent only.
See, design is only about aesthetics, how it looks like. My phone has a camera on it.
Yes.
What are the ways in which those cameras have been designed? Only the aesthetical look would classify under a design, nothing else.
Okay.
Algorithm itself will not classify as a design.
Okay.
It has to be the design itself, the way it looks like.
Okay, sir. Thank you, sir. Thank you very much.
Sir,
Yes.
sir, as you were explaining about the registration of the trademark, that time that registration, is it geographically restricted, sir, like patents?
Yes, so all the IP, everything in IP is geographically limited. Even the trademark would be geographically limited. If as I said, if my company name is effectual, it is only, and I protect a trademark in India, my rights are limited only in India. I can't enforce my trademark rights if somebody else uses the same name in US, Europe, or somewhere else. It is that the only way that you could do is if you create a reputation globally in such a manner. As I said, let's say Pepsi or Coca-Cola of the world, they have a brand name which is known globally. Even if they have not filed a mark in a particular country, still they may have legal rights because it's a long-term use of their marks at a global level. I'm not using my mark at a global level. So it depends upon how you're using your marks. But typically it's limited to a territory. It is limited to a particular territory. Any questions, please?
Yeah, but I will request you during the tea break, you can have the one-to-one discussion and you can ask your queries.
Sure. Thank you so much.
Thank you, sir, for that insightful session. Your comprehensive overview of the basics of intellectual property has surely set the stage for a deeper understanding of the crucial subject. Now I would like to invite Dean of the Department, Dr. Ashok Bhansali, sir, to give the certificate to Dr. Amit Goyal, sir.
Please join me to welcome Mrs. Swati Bajpayee, the esteemed founder of One Stop Solution based in Faridabad. Ma'am, your presence is an honor for us. I would like to invite Dilip sir and Dean of the Department, Ashok sir, to welcome Swati ma'am.
Background.
Thank you, sir.
Now before we dive into our next session, let's take a short break to refresh ourselves. Please make the most of this opportunity to network and engage with your fellow participants. Once again, thank you all of you to be here today. Let's reconvene shortly to continue our exploration, intellectual property and rights. We will meet you all after 15 minutes. Thank you.
So 15 minutes